Alrighty, welcome to the First District. We have one case to be argued today, which is U.S. Bank versus Thai. Good morning, Mr. Engel, Ms. Folman. Mr. Engel, you may proceed when you're ready. And would you like to reserve any time for rebuttal?
Yes, sir. If I could reserve 3 minutes, please.
You may.
My name is Andy Engel. I'm here on behalf of Kenneth Thai, the appellant in this case. As the court knows, this is not the first time this case has visited this courtroom. And frankly, not much has changed since the last time when this court dismissed for lack of a final appealable order. What has changed is that the trial judge did put on an amended order adopting the magistrate's decision. However, that order just, in a cursory kind of way, said Mr. Thai's objections had been considered and overruled without any analysis at all.
Was that analysis required, though? Or the fact that she acknowledged that she reviewed the objections is not going to...
Perhaps not. I was just leading up to my next point that this is one thing that really frustrates Mr. Thai, because the magistrate's decision was the same way, that in fact there was really no consideration or analysis of his arguments. And that's really what he is hoping for, is to get a fair hearing on his claims. This is one of the first issues I want to discuss, which of course is the first one you always look at, is whether there is currently a final appealable order before the court. I would frankly love for the court to reach the merits today, but there is one problem in this case with regard to counterclaim, or cross-claims, excuse me, that Mr. Thai asserted against Taylor, Bean, and Whitaker, the prior mortgage holder, or perhaps the current mortgage holder. We really don't know. As the court knows, plaintiff filed an initial complaint, ended up amending that complaint to add Taylor, Bean, and Whitaker because of an issue with the mortgage assignment chain. When that occurred, Mr. Thai asserted cross-claims against Taylor, Bean, and Whitaker.
But then there was a default judgment.
There was a default judgment, and I apologize about that. Frankly, I kind of missed that. I'm not quite sure how when I did my initial brief, so I take the blame on that one. I didn't mean to mislead the court in any way.
So they're out of it. TBW is out of it.
Well, no, I don't believe so, Your Honor. And the reason is that Mr. Thai asserted cross-claims against Taylor, Bean, and Whitaker, seeking a declaratory judgment that they, in fact, were still the holder of the mortgage and of the note. Those claims remain pending, have not been determined. The problem with that is that plaintiffs or appellees claim against Taylor, Bean, and Whitaker, and my client's claims against Taylor, Bean, and Whitaker are basically the exact opposite of each other. One set of claims have been determined, the bank's. Mr. Thai's claims have not.
But I thought the court's determination was that TBW had no interest in the property.
That's correct. That doesn't necessarily define the answer of who does hold the mortgage, though. The court decision did say that Taylor, Bean, and Whitaker can no longer assert a claim in the property. Right. That did not necessarily address, who was ultimately the proper party.
But that can be litigated here on the merits, right? Whether Taylor, Bean, and Whitaker's out of it. They can't assert any claim to the property. So now we just determine whether U.S. Bank can.
Well, and that's fine if that's the way the court wants to view it. I view it differently because Mr. Thai has asserted these claims against Taylor, Bean, and Whitaker that remain unadjudicated, that say the exact opposite, which kind of presents a little problem, I think. But if the court wants to, make that finding, that's fine. I want to get to the merits of the case, so I'm perfectly comfortable with that. Excuse me. So this case is here on summary judgment, and as the court knows, it undertakes a de novo review of what occurred in the trial court. One of the major issues that Mr. Ty raised and argued in the trial court related to the notice of default. And there are two real big issues with that from our perspective. The first is whether the current servicer's employee could authenticate a letter sent by a prior servicer. And I do not believe he can, but more particularly, there was no evidence submitted at the trial court that the notice was actually ever mailed. More problematic, however, relates to whether, under Ohio law, a notice of default sent by a prior lender can be used by a current foreclosing plaintiff. There kind of appears to be a split in Ohio. I don't necessarily believe that's true.
Is the issue whether it can ever be used by a current lender, or only is it if the first issuer had initiated litigation and then dismissed the claim, then are you saying, is that the rule that you're espousing?
I don't believe they ever can. That a subsequent.
So in other words, like on day one, lender A issues notice of default. On day two, they transfer it to lender B. You're saying lender B cannot proceed on that notice?
I believe that to be the case, Your Honor.
And why though? I mean, why couldn't they?
Based on the reasoning set forth in the second district in the Young and Clark decisions, because of what the second district said was a plain reading of the note and mortgage. The note requires that a notice of default be sent by the, quote, note holder, a defined term. And in the mortgage, there's a similar provision that says the lender, which is generally defined as the mortgagee.
So Young didn't depend on the fact that there was a lawsuit instituted and then dismissed? I mean, because wasn't that the facts in that case?
I believe that's correct, yes.
So you're saying the case didn't hinge on that fact?
No.
They're just saying blanketly that you can never do this?
I believe that to be true. And there's actually a very much a substantive reason why this is important, and it relates to the right of reinstatement. If you look at paragraph 22 of the standard Fannie Freddie mortgage, it's entitled acceleration. And it talks about that acceleration is based upon providing this notice. The notice contains more than just, hey, you're in default, you have to cure. It also contains information about reinstatement, which is an absolute right that a mortgage borrower has under the mortgage. If you look at the Nation Star Notice of Default, which was issued in March of 2014, it discusses, okay, if you want to reinstate, send your money here to Nation Star. At this point, with the new lender, Mr. Ty did not have that information as to, okay, what do I do to reinstate this mortgage? What's the amount owed now, 4 years later, which is the problem that we're faced with. So I believe the reinstatement of the mortgage is an important additional right that the mortgage requires be provided with the notice of default. Okay, they're often combined as the notice under the note and notice under the mortgage are combined in a single one, but they actually have two slightly different purposes, or at least contents.
You said there's a district split on this?
Yes, Appellant cites the 6th district, I believe, case of Mayo. And I actually don't think that this creates a split because of what happened in Mayo. In Mayo, the court actually, I believe their analysis on this issue is dicta, because the court first said that we don't need to reach this decision because it was not properly preserved by the property owner through a Rule 9 defense regarding lack of satisfaction of conditions of proceedings. So we don't even need to reach here because it was not properly reach this issue because it was not properly preserved. It said, nonetheless, if we were to consider it, blah, blah, blah. So I don't necessarily think that discussion in Mayo is really the holding of the case or would create a district split. Right now, I'm only aware of the second district cases that I've cited. I next do want to talk about the mortgage assignment. And I understand there is law in the state of Ohio that says I'm not allowed to talk about it. I explain my reasoning for why I think that's not really quite the law, and it certainly shouldn't be the law. I know of no other instance in which a plaintiff has the burden of proof on a particular fact, and the defendant cannot contest that fact.
Can I ask you, though, on this issue, my understanding is that U.S. Bank actually is the holder of the note. Is that correct?
That was the conclusion of the trial court. Yeah, that's the record before the court right now.
Okay.
That's right.
And so if they're the holder of the note, why does the mortgage assignment challenge matter?
Because, as I said, of what it has to do with who else out there could be entitled to enforce that mortgage. The equitable assignment issue is just that. It assigns only an equitable interest. It does not assign the legal interest in the mortgage. So you've still got someone out there potentially.
But I thought that was the whole purpose of what the trial court was sorting out was, is there anyone else out there who might have an interest, right? I mean, haven't we figured that out at this point?
I don't think we have, Your Honor.
Who else might have an interest?
The bankruptcy trustee in Taylor, Bean, and Whitaker's bankruptcy. And that vests as a matter of law, and it's not going to be apparent on the face of the land records here in Hamilton County.
If U.S. Bank holds the note, how does the bankruptcy trustee come forward then to say, I have this interest?
Well,
after their claims have been adjudicated.
except that the trustee's claim could not have been adjudicated because the trustee's not a party to the case.
But it steps into the shoes of TBW. It has no greater rights than TBW as a bankruptcy trustee.
That's true, but the problem is TBW, when the bankruptcy is filed, loses its ownership rights. Those are vested in the trustee. It's a mess, don't get me wrong. This is kind of ugly. But the problem is we don't know who, in fact, might hold an interest. For example,
would you agree, though, that Ohio law says that the holder of a note endorsed in blank is entitled to enforce the mortgage?
I actually do disagree with that on one very specific point. If we look back at the Cuck v. Summers decision, I believe it said that someone who takes the note via negotiation. And maybe I'm splitting hairs that I do that a lot. I apologize because you used the word holder, so yeah, okay, sorry, you're right.
Okay, so U.S. Bank holds the note, right? U.S.
Yeah.
Bank holds the note, so they can enforce the mortgage?
They have the equitable rights under the mortgage, yes, and Ohio law says they can enforce it. I would agree with that.
So that's why I'm trying to understand why it matters whether you can challenge the mortgage assignment. What does that matter anymore?
Because, as I just explained, I think the fact that this corrective mortgage, I don't know a universe in which that actually does anything. It's like kind of like saying, ignore the man behind the curtain. Because, in fact, all the people we don't know whether we've gotten everybody or not. Now, I understand that's theoretically true in every case, okay? I understand.
And Mr. Ingo, you've exceeded your time. If you want to reserve any.
Yes, I would,
time.
thank you.
But were you finished with your response to Judge Cross's question?
Only in that, I think I addressed that earlier with the bankruptcy trustee. So thank you.
Thanks.
Thank you. Ms. Volman, good morning.
Good morning, Your Honors. May it please the Court. My name is Brianna Volman, and I represent Appellee U.S. Bank in this matter. U.S. Bank asks the Court to affirm the trial court's grant of summary judgment. Today, I will address 3 issues. Is there a final appealable order before this Court? Did the trial court directly determine that U.S. Bank is entitled to enforce the note? And did the trial court correctly determine that U.S. Bank is entitled to enforce the mortgage? The answer to
could
all
you-
three of those questions is yes.
And could you maybe start with the point that Mr. Engel was discussing about whether U.S. Bank has the ability to enforce the note after there's been a notice of default and foreclosure by a prior lender? That lender has then engaged in litigation and then has dismissed the claims. Because there is some intuitive sense to that in terms of your lender enforces it and seeks to litigate it, then dismisses his claims. You as the borrower say, okay, this is over, and now another lender comes in and says, wait, we're going to piggyback over that prior notice. Does that make sense?
I understand the question, Your Honor. I don't think it would make a difference here. Mr. Tai has been in default for almost 10 years, so the argument that he would be prejudiced by not receiving a second notice of default when he was still in default does not hold any weight.
It's not whether he's prejudiced or not. I realize kind of the common sense response that you're giving. It's whether the law requires there to be another notice regardless of whether there might be prejudice or not.
No, it does not, Your Honor.
And so how do you respond to the two second district cases that he advances in the brief?
So as you've pointed out, Mr. Tai argues that U.S. Bank cannot rely upon a notice of default sent by a prior servicer, which is incorrect. First of all, Your Honor, U.S. Bank presented evidence that the notice of default was sent. Exhibit E, attached to the mortgage servicer's affidavit, is the notice that was sent. No contrary evidence was submitted, Your Honor.
I'm sorry, forgive me on all the exhibits, but was notice Exhibit E, was that a notice from U.S. Bank?
No, Your Honor, it was from the prior servicer, which inures
Okay.
to the benefit of the current servicer.
Yeah, I think we're all on the same page that there was some notice sent. It's the question of whether that had to come from U.S. Bank to perfect the conditions precedent.
It did not, Your Honor. Under the mortgage, it is the notice of default has to be sent, and it was. It certainly does not have any specific language regarding what lender or another, and it's certainly proper under Ohio law that the notice inures to the benefit of the current holder.
But how do you distinguish, as Judge Bergeron asked, the second district case,
Are you referring to the case that,
the Young case?
well, yes, you mean the case that there was prior litigation?
Yeah.
So that was not an argument in the lower court, Your Honor. There was nothing on the record regarding the previous litigation that was conducted by a mortgage servicer. So
Can we take judicial notice of it?
you probably could. However, it would not be determinative of any of the issues, Your Honor, because again, the notice under Ohio law inures to the benefit of the current lender.
But
So-
not if there was, under this particular case, if there was prior litigation that was dismissed, then it doesn't.
It was,
Everything has to start again.
so Mr. Tai tried to assert that argument in a footnote, Your Honor, and yet there is nothing in the entire trial court record whatsoever that that case even existed or that argument was being asserted.
What is that? I mean, I'm just trying to figure out what the law is.
The law, in that specific circumstance, under the facts of that specific case, it was a very narrow holding, Your Honor, and I do not think that it applies here.
So just to make sure I understand, are you saying that this argument is waived?
Your Honor, I would argue, yes, that it's waived.
'Cause
It was not made in the trial court.
I'm looking at your brief right now, and I'm not seeing an argument in your brief on this point that says it was waived.
Well, because it was not made in in even the briefs in the trial court, Your Honor.
Right, but you're addressing it on the merits in the brief. Like, I don't see an argument in your brief that says they waived that argument. So that's why I'm just trying to understand.
So the reason you don't see it in the brief is because it did not appear in Mr. Tai's brief.
No, he made the argument in his brief. He
Are you
relied on
referring to the
those-
footnote?
No, he relied on the second district cases. Am I misremembering that?
Isn't this an issue that was raised under assignment of error 3, whether U.S. Bank can rely on a notice of default sent by a prior owner or servicer of the loan?
If it was, Your Honor, I just want to direct the court's attention back to the law that is on the books, that is that U.S. Bank can rely upon a notice of default sent by a prior
And
servicer.
you're saying the second district case that he cites.
It's in a positive,
And why is that?
It's because that is not the circumstances presented in this case.
Because it seems like it kind of is the circumstances in this case, because there was a lawsuit that was filed and then dismissed previously by the prior note holder, right?
Correct.
And that seems very similar to the second district case.
Your Honor, it does seem similar, and the court can make what it wants of it. However, I would like to direct the court's attention to what the general law is, that the prior notice of default sent by a prior servicer inures to the benefit of the current servicer.
And so that's what we're trying to get at. So can you give us a case that stands for that proposition, that the notice sent by the prior lender effectuates proper notice from the current lender, even if they didn't send it?
Certainly, Your Honor. It's P.E. Alms Hill Realty. And also, Wells Fargo versus Mayo also stands for the general proposition that the prior notice inures to the benefit of the current servicer.
Let me ask you this question, ma'am. You indicated that this note and mortgage have been in default for about 10 years. And assuming that the defendant in this matter received the notice of default, because that changes every day based on interest and accruing interest. So he's got one from, 10 years ago, 5 years ago, whenever it was, and that's no good anymore. You can't reinstate that, right? Because every day it changes a little bit. So you're saying the initial notice of default is good enough despite the fact that it's supposed to advise the person in default of the amount owed and how to reinstate?
Yes, Your Honor. That's what's required on the mortgage, and that is what U.S. Bank's obligations are. And during litigation, Mr. Ty could have requested through discovery more information of the balance of the note or challenge the balance that U.S. Bank asserts is left on the note, and that didn't occur, Your Honor. This is in litigation now. Mr. Ty has been represented by counsel the entire time, and if there was concerns regarding the fact that the notice of default now has accrued interest and such, then he could have requested discovery so he would have understood specifically the amount owed, which that's not Your Honor, the balance due was averred, and there was no contradictory evidence presented.
Let me ask you this then, is the fact that Mr. Ty appeared and defended, is that good enough notice? Is that good enough?
You mean,
I mean, is that he appeared, he obviously knew he's in default, because he showed up and defended,
Certainly.
right? So now the only question is whether he knew the amount or how to reinstate the loan. It's like a case that would go all the way through to a jury trial, and then at the end, someone would raise some issue, like statute of limitations or something like that. Is the fact that he defended indicative that he had notice? Does that make sense?
I would say so, Your Honor.
Okay.
Absolutely. I mean, this is obvious. This is not the main issue in this case. The main issue is that the trial court granted U.S. Bank summary judgment based upon its possession of the note and its right to enforce the mortgage that follows it.
What's the purpose of the notice of default then?
The notice of default is an obligation that is found in the mortgage itself, and it's just a precondition that
Being able to file a foreclosure action?
Yes, ma'am.
Okay.
Yes, Your Honor. So I just want to also address the final appealable order issue, just to make sure. Under Ohio law, without question, an order determining that the mortgage is the first and best lien upon property is a final appealable order. That's determinative of the issue. U.S. Bank was determined to have the first and best lien.
Well, can you address his point that there's a pending cross-claim that hasn't been adjudicated?
Yes, Your Honor. The cross-claim is irrelevant. First of all, cross-claims are non-compulsory, and the court has already determined that Taylor, Bean, and Whitaker does not have an interest in the property. So the argument that no final appealable order can exist while that cross-claim is pending, it fails. The pending cross-claim.
I think like what we're faced with from a final appealable order perspective is that sometimes there are almost hanging chads at the trial court that are claims that people forget about because they're not the main claims, whatever, but they have to be adjudicated. And even if the trial court's decision seems to be indicative that that claim would have failed, like, we still need it to be adjudicated to exercise jurisdiction. So that's what I'm trying to get at here.
Certainly, and I believe it was adjudicated, Your Honor. The default judgment, coupled with the order decreeing foreclosure that specifically said that no other party has an interest in the property, certainly that completely erased all possible interests that Taylor, Bean, and Whitaker might have had. And also, Your Honor, as you know, this litigation has been ongoing for 6 years, and not a single entity has come forward to have an issue or claim an interest in this property, and that's because there isn't one, Your Honors. U.S. Bank is the holder of the note endorsed in blank. It was filed in the trial court. Here it is. They absolutely, under Ohio law, are the holder of bearer paper, and they absolutely are entitled to enforce the note. And absolutely, all these issues are important with whether or not the notice of default was sent, but U.S. Bank presented evidence that it was sent. There was no argument regarding whether or not the balance due was accurate or not. So the trial court properly held that U.S. Bank was entitled to enforce the note, and specifically also, they also properly determined that they were able to enforce the mortgage. Under Ohio law, without question, as Your Honors pointed out multiple times, that the mortgage follows the note it secures. U.S. Bank's possession of the original note endorsed in blank is determinative of the issue. The corrective assignment, whether or not it was invalid, it was valid. The corrective assignment, coupled with the judicial default, is an independent reason for this court to uphold the determination that U.S. Bank is entitled to enforce the mortgage. And again, even if the assignment was not valid, which it was, the physical transfer of the note endorsed in blank, which the mortgage secures, constitutes an equitable assignment of the mortgage, regardless of whether the mortgage actually or validly was assigned or delivered. And for that proposition, it's Deutsche Bank versus Nasher, Your Honors. Also, any of Mr. Tye's arguments relating to the records that the prior servicer relied upon, or that the servicer relied upon, is incorrect. The adoptive business record hearsay exception, without question, allows U.S. Bank to rely upon the records of a prior loan servicer. However, it should be noted, Your Honor, that U.S. Bank did not have to submit a payment history in order to be entitled to summary judgment. Under Ohio law, an affidavit stating that the loan is in default is enough. Further, Mr. Tye also argued that U.S. Bank could not rely upon the notice sent by a prior servicer, which we talked about. I do want to point out again that Mr. Tye did not present any contrary evidence relating to whether or not the notice was sent. That completes U.S. Bank's, not only are they carrying their burden, but that completes their obligation under the mortgage to send that notice of default. And U.S. Bank presented evidence that it indeed was sent. The burden shifted to Mr. Tye to rebut. He did not. Therefore, the trial court found the notice of default sufficient, and that determination should be upheld. And even so, like I've said multiple times, under Ohio law, the prior notice sent by a prior servicer inures to the benefit of the current servicer. This happens all the time in loan servicing, loans shift hands. If parties were not allowed to rely upon documents from a different servicer, then there would be chaos. Your Honors, the adoptive business hearsay exception, without question, allows U.S. Bank to rely upon all documents that were attached to that affidavit and properly adhered to.
Thank you so much for your argument. And Mr. Engel, you have 3 minutes for rebuttal.
Thank you, Your Honor. Just want to hit a few points. First, relating to the notice of default, contrary to counsel's suggestion, there was in fact no evidence submitted in the trial court that such a notice was sent. What was presented were copies of a notice. We have no idea whether that notice was actually
Well,
sent.
Can I ask you about
Sure.
her point that you didn't even raise this argument below? And I'm looking at a footnote in your brief on page 14 that acknowledges that there's no documentation about.
Correct. I didn't handle this case at the trial court, so I picked up the file and I was a little distraught to see that there was no reference to the 2014 Nation Star foreclosure case. I just wanted, that's why I.
Yeah,
put
no,
the
I
footnote in.
appreciate that. But then if none of this was before the trial court, is it properly before us at this point?
Well, I don't, as I said earlier, I don't think it matters that there was a prior case that was dismissed. I follow what the court in Young said in the second district.
Because your position is, as long as it wasn't from U.S. Bank.
Correct.
They haven't met.
It doesn't matter whether there was a prior foreclosure or not. Judge Winkler, there was one thing you said about the balance changing every day. That's not technically true because this isn't a payoff statement. It's a cure notice, so it goes monthly. So it would change every month, not every day. But I do want to talk briefly about the adopted business records. I don't dispute that such a doctrine exists. I don't dispute that Ohio courts use it. Of course, I don't necessarily like how they use it sometimes, but I want to focus on the one requirement that everybody seems to skip over, which is regardless of who prepared it and how the document was managed by the prior servicer in this case, there still has to, the proponent of the evidence still has to satisfy the elements of Rule 8036. And that wasn't done here because their affiant never said, I know how Nation Star, or I know how Saxon, or I know how Taylor, Bean, and Whitaker prepares their records, and these were prepared in accordance with those elements of 8036. There was no testimony about that before. And although I understand the argument that a payment history is not required, I disagree with that for a couple reasons, but that is the method by which they chose to try to prove the amount due. That was the evidence they presented. That's the evidence that was responded to. I don't believe that an affidavit by itself is enough because you've got a hearsay issue with that, but that's not really before the court. If there are any other questions?
And you're at your time. Thank you both for your arguments today. The case will be submitted. We'll get out a timely written decision and hope you all have a great day.
Thank you so much, Your Honor. Get out of town before the storm.
Yeah.